to Boksburg Magistrate Court. The state further led evidence that a thoroughly in sound and sober senses, without being unduly influenced, before a magistrate, Mrs. Vivian Cronier, who also confirmed that she participated in the taking of the confession in the services of an interpreter. Ms. Mutlaping was also used, and the state submitted evidence through Mrs. Cronier that accused number 2 signed the statement, and that has been confirmed by Ms. Mutlaping, who gave evidence that she's the one who gave accused number 2 a pen to sign. The state further alleges, after the taking of the alleged confession by the learned magistrate Cronier, to taking accused number 2 back to Pretoria Mort, where he was booked in. Then the evidence of the state further is about the first appearances of all the accused in Boksburg Court on the 27th of October 2020. Before their appearances, the state led evidence that on the 26th of October 2020, they formally charged the accused. On the 27th of November, the state further led evidence on the second appearance of all the accused before the magistrate in Boksburg, and the 5th of March 2021. My Lord, in summary, the defense is going to respectfully submit that from the evidence given by accused number 1, that he was assaulted, that he was tortured, that he was choked, it's the evidence that the court at the end of the day will make a ruling in terms of whether there was such an inducement. Accused number 1 says, yes, after I was assaulted, I had no choice. I had to protect my life because there was no one who could assist me. He had no option but to sign a statement. Then the defense will later then address legal issues in terms of the admissibility of such processes of proceedings of recording a confession. It's evidence also by accused number 1 that pointing out of the 5th of June 2020, it did not point out any place. He disputes that he directed the driver to a place where the alleged offense, or a particular place in Vosloorus, of Colonel Khadebe, who said, accused number 1 said, I'll be able to. What is to be decided by this honorable court? Firstly, without wasting the court's time, we want to look at how accused number 1 was arrested on the strength of a J50. It is the submission by this defense that application, as when the evidence is compared to evidence of Brigadier Linda, who told this honorable court that he brought an application in Boksburg Magistrate Court. In relation to evidence by Sergeant Mkhola, firstly, the investigating officer, if he or she is not a commissioned officer, cannot bring an application before a magistrate. That proposition is, and the support of Section 43 is cited in Maposa versus the Minister of Police. My Lord, I think the full citation is on my head. But there, in that case, we have, it's a civil suit, averred that he was unlawfully and wrongfully arrested on the strength of a J50. On the facts of that case, to support the principle is that Warrant Officer Comradi prepared an affidavit in support of the application. Colonel, is that a proper application was brought that warranted to deprive the liberty of accused number 1. That J50 upon which accused number 1 was arrested on its strength was illegitimate. Hence, the defense will move a submission that it was an irregular process to arrest accused number 1 on the 30th of May 2020. On the arrest of accused number 1 on the 19th of March 2019, he was arrested without a warrant of arrest. And the provisions of Section 40, 1, I think subsection B, subject to confirmation, my Lord. But the importance and the significance of that evidence is that, firstly, the state did March 2019 to move forward in what actually transpired. The defense will submit and argue that Colonel Mboto, in terms of Section 2, had no, this is what the defense will submit, that in terms of his rank, he is a commissioned officer. And this has been put to Brigadier Kininda when he testified as the head of the investigation. that there is a certificate which is issued for a person to be a justice of the peace. It's an A4 size certificate, and in terms of section 217, 1A, confession made before a non-judicial officer. That provision relates to a confession to be taken before a magistrate. And the question of law is, who is the justice of the peace in terms of that provision? It is apparently clear that the powers conferred to the appointment of the justice of the peace are provided or prescribed under section 334 of the Criminal Procedure Act, whereby it is stated that the National Commissioner is the one who appoints a justice of the peace on various districts. And it also, that provision, section 334, 1, and other relevant provisions, deals with specific matters to be taken to a justice of the peace. There is no amendment of section 217, 1A that is prescribed to include all the colonels as justices of the peace because of their ranks. That's my submission, that before this honorable court, it has not been proven by the state that Colonel Mboto produced that certificate. Colonel Rapatu. Colonel Rapatu, when I came on board, I canvassed this aspect with him during cross-examination. He took out an appointment certificate and said he was appointed by Ria Pierre, the National Commissioner. That's not what is required. That's the submission of the defense. Number two. Sorry, my lord. May I just have a seat? The defense would like the court to look at the date, the time accused number 1 was arrested. He was arrested, I think it was 12 minutes past, it's 12:30, according to the evidence of the state, but that is not in dispute. When he was arrested, on the same day, at night, the state alleges that he volunteered. There's something on my shoulders that I wanted to offload. This is the right time. The question is, arrested. To offload, important aspect that is important for the for Colonel Mboto to take a confession, even Colonel Rappard, without the assistance of the interpreter. This is what Judge, I think it's Judge Brooke, in State versus Koki. This is what Thomas, the questionnaire in terms of English, is at stake. It is also contended, it is also submitted, it is also held in that matter of State versus Koki about the involvement of a commissioned of a person who is taking a confession, and it is made in the same department by the police officer. That's why he mentioned in paragraph 53 that the legislature, magistrates should be used to take confessions. But this is the summary of what I've submitted in my written heads, my lord. So, my submission is that both and number 2 must not be considered as confessions that the commission officers complied with the provisions of section 217.
Even Mrs. Kronje.
Now I'm getting to Mrs. Kronje, my lord.
I see.
My lord, may I request Mr. Ramsipiti to read it for me?
What is the reason?
Is it paragraph?
Hello?
Paragraph 50, my lord.
Yeah, fine.
Yes.
If it may please the court, my lord, I'm reading from S versus Polki. The citation, I believe it's in Mr. Mgomezulu's arguments. At paragraph 50 thereof, the court remarked, all too frequently commissioned officers who record confessions do not use the services of an interpreter. That he or she and the suspect may both speak the same language, in this case is Xhosa, is not the only consideration. Questions on the pro forma are set out in English, so too are recorded answers as have been made by the suspect. The statement itself is recorded in English. What is never known is the competency in English of any particular commissioned officer. He or she is not a sworn interpreter. In court proceedings, they most often give evidence making use of the services of an interpreter. The reliability and accuracy of the statement is frequently called into question. It is frequently asserted that the statement was not recorded correctly and was not read back to the suspect, whether in English or in the language of its origin. Many of the routine concerns surrounding the accuracy of the record of proceedings pertaining to the obtaining of a confession and the level of compliance thereof required by the Constitution of those taking the statement could be overcome by having the additional input of a sworn interpreter during the process. Interpreters form an integral part of the magistrate's court proceedings. They also can be added to by the observation that the use of an interpreter would also be of great assistance in the attainment of the constitutional goal, a fair trial. Okay. And then we go to paragraph officer of the same force which is charged with the investigation duties. This would go a long way to ensure that the quality of the investigative work shows improvement, which is necessary to ensure an improvement in the rate of successful prosecutions for serious crimes in this country. I have little doubt that the members of the South African Police Services were aware that at some point during their investigation, there may well be magistral scrutiny of their background, leading to the recordal of a confession. There would be a resistance on the part of the investigation team to resort to the improper use of police force or violence.
Yeah.
The defense in relation to the admissibility of such confessions where an interpreter was not involved. There is that likelihood of misunderstanding. The court on the 8th of June 2020, accused number 1 pointed out the state must prove beyond reasonable doubt that a particular confession in terms of section 217 or a pointings out in terms of section 218 or an admission in terms of section 219 capital letter A must have been made freely and voluntarily in sound and sober senses without being influenced that way. It's my submission that the state has dismally failed to prove those elements, those requirements. In the state's failure to prove those elements dismally, the state did not satisfy this court that the rights of both accused in terms of section 35 of the Constitution were properly explained. And besides being the rights being explained to the suspects or to the accused person, accused 1 and 2, the question is, if accused number 1 was arrested on the 30th, if the law requires that he must be taken to court within 48, the state contended, why was he still kept? Or why? I submit that when one looking at the definition of a confession, it's an unequivocal admission of guilt. So, in the confession, why was he not taken to court? Instead, the state used a strategy to investigate the case of Senzo Meyiwa whilst keeping the accused in. I'm not quoting my colleague Advocate Baloyi.